The Open's just about to start.
Okay, thanks.
Okay, go ahead.
Good morning, everyone, and welcome to Law Talk. Today's topic will be mistakes that you can avoid while you're making a contract on your own if you choose to make a contract without an attorney. I, of course, always think if it's important enough to have a contract about, it's important enough to at least consult with attorney about. You don't have to have the attorney write the whole contract up, but a consultation is usually pretty cheap, under $100, and at least in this area, and you can really avoid some problems. So last week we talked about the elements of a contract, what it is that makes a legal contract. And we talked about there has to be something of value exchanged on each side. You have to have terms that specifically say what it is that you're contracting over, who's supposed to do what. And it has to be like a legal topic. And, so there are other elements. Now, last week's Law Talk is on YouTube, and it also streams live on Facebook. And so you can take a look at that if you missed it. But what we're going to talk about today is mistakes people make when they're making contracts. And we'll talk about some really big mistakes that have been made even by professionals. But what I really want to talk to you about how you can avoid making mistakes when you make a contract. So the first thing to make sure is that you have it in writing, because people's memories are dim and they don't always remember exactly what it is you contracted to do. So if it's not something that's going to be done today, like you fix my plumbing and I'll pay you by the hour, then you want to have the contract in writing so that nobody forgets what it says and so that it's enforceable. So one of the things that people forget to do when they make a contract that's in writing is to say what happens if someone doesn't live up to their end of the deal. Now, when you remember to put that in, and it's not required for a contract, but it's a mistake not to include it, it's called liquidated damages. That's the legal term. So it says, what if this contract has to be put aside because somebody didn't do what they needed to do? That's a liquidation, just like when you liquidate a business and they sell everything. It basically means we're dissolving something legal, so we're dissolving the contract. So what can that be? Well, you can say, you have to do something, and if you don't, then it's $10 a day for every day you don't do it until you do it. It could be that you have to give back something that you have, or that you have to give something back, and something else if the something that you have loses value. So, for example, in contracts involving the purchase of a vehicle, the car company normally, if you buy a new car and you don't pay the debt, the car company, if they are financing it directly, or the bank or finance company, can take your car back. But they can't just take your car back. They can also go after you for any deficiency on the loan, for fees involved, having the person go get the car and give it back to them. So it's not just a matter of taking it back. Their liquidated damages include the fee to go get the car from the repo person. It includes the extra interest and everything on the loan until you pay it. So there are all kinds of additional damages that the car company can get. Now, what happens if they don't deliver you a good car? Well, under contract law, that you have remedies if the car is a lemon, and under New York State lemon law, you have all kinds of additional remedies. It's always good to have it in writing what the remedies are. And so professionals, when they're making a contract that are written by professionals, usually try to remember to put that in. Sometimes you need to go to court to enforce your rights or your remedies in a contract. And in New York State, we have what we call the New York rule. And the New York rule is nobody gets attorney's fees for going into court for a contract. So the judge can't even award them if you don't put it in your contract that they can. And it's been my experience that unless somebody has really done something outrageous, it's not just a mistake, it's not something unavoidable. It's not something excusable. If someone is really outrageously violating the contract terms, they may award attorney's fees, but it's so rare that you can't assume it's going to happen. I've had people come into my office and say, "Well, you're going to get paid by the other side," and they think they don't have to give me anything up front. And I say, I always need money up front, unless I'm doing it as a pro bono case, which I only have one or two of those at a time because that's all I can spare to do. But let's say you're working for me or another attorney for month, then the money's involved. They usually want the money up front, even though it says the other side is going to pay your attorney's fees. So if the judge awards attorney's fees, they can have them awarded to you, and then if you your attorney will take the money, take whatever you owe them still, if you still owe them some money, if it goes over your initial retainer, and then give you the balance. But you'll never get more money than your actual attorney's fees for attorney's fees. So there's no point in putting in saying, well, you'll pay me $10,000 in attorney's fees, and then it turns out it only costs $3,000 to enforce your rights. You're not going to just get to keep that $7,000 as a windfall. You would only be awarded $3,000, and frankly, you'll be lucky if you get that. What I normally see judges do is award partial attorney's fees. So if they award them at all, and again, that's not a frequent thing that happens. It's only if there's outrageous behavior, and so we'd have to spend another whole show talking about what's outrageous versus what's normal contract breach. So you're probably not going to get your attorney's fees, but if you want to have any hope or prayer of getting your attorney's fees, you need to make sure it's in the contract saying if the other person violates, the violator pays the attorney's fees of the party who was injured by that violation. Now, there are other remedies that can happen. I mean, some ways that a judge can fix a violation is to make everybody do what they're supposed to do. And sometimes it can be hard or impossible to make people do things. But let's say, for example, we're talking about a sale of real estate, and the person doesn't do the sale. You've come up with the money, whether you bought it on a land contract or some other way, and or you've been ordered to get real estate in a divorce or other civil action, but the person just won't sign the deed over to you. Well, one of the alternative remedies that you have, besides trying to get the person to sign the deed over to you, is to go to court and make a motion for a sheriff's deed. And a sheriff's deed is a deed that the sheriff signs, sounds just like what it is. The sheriff signs the deed, and that's just as legal as if the owner had signed it. When a sheriff signs a deed under court order to sign a deed, then you can go ahead and file that deed with the county, and you own it just as much as if the owner had signed over the deed to you. So there are other remedies that you can get that give you what we call specific performance, or exactly what the contract called for is specific performance. And it's not always requiring the person's cooperation to do that. Again, that is a situation where you'd be more likely to get attorney's fees, because if someone won't even sign over a deed for land they sold to you, unless they are incompetent and no longer able to sign over the deed, or there's other good excuse why they can't or won't, then that would be a situation and an example of when you might be able to get attorney's fees, because you shouldn't have to go after someone to sign over a deed to real property. And by definition in New York State, if you've got a real property transfer, then you have a written contract, because there's no such thing as an oral contract for real estate in New York State. There are other ways, for example, we've talked about constructive trust and other things, but those are rare. If you're going to get real estate transferred to you through a purchase and sale, you need to have a written contract. Otherwise, you're not necessarily going to get that real estate if it winds up in court. It's only the good faith of the person, and assuming that they're still alive, et cetera, that you're going to wind up with that real estate if you don't have a written contract, because it's required in New York to enforce it. Rights to land are so important and so valuable that the courts require, the state requires, that you have a written contract in order for it to be enforceable. So you really want to make sure that you do that. Another remedy, let's say that you don't want to enforce it specifically, that the other person hasn't done what they're supposed to do, and you just want to walk away from it. You don't want to deal with this person anymore. This is more likely in a services contract. So if you have a deal where someone is going to perform some service for you at your home, for example, and they've come to your home and they did whatever they did, and it was not satisfactory. And so you gave them an opportunity, and you always do have to give them an opportunity to come back and fix it before you go to court. So you gave them an opportunity to come back and fix it, and it's not fixed. It's just no good. And so you don't want to give them the rest of the money. In fact, you'd like to have the money back that you already gave them, because they did such a terrible job, and it's going to cost you maybe more to fix it than it did to give what you gave them in the first place, because the next person has to not only fix it or complete it, but they have to undo whatever it was the other person did. Let's say you're in that situation. So then you wouldn't want specific performance. You wouldn't want the person to do what you contracted for them to do. So we're going to come back in a few minutes and talk about what happens then. So for those of you on Facebook, Law Talk is a commercial show, it's not considered a public service like the FCC used to require. They don't require that anymore because there are so many other avenues where people can get information online and such that they don't require a certain amount done by a radio station or a television station for, public service, commercial free, blah, blah, blah. So we are commercial radio, and this is our commercial break. You on Facebook can't hear the commercials, I guess, because the advertisers, they didn't pay for that. So maybe against Facebook's rules or whatever, I don't know. But in any event, if you're on Facebook, you're not hearing the commercials that are going on over the air. If you're listening to it on 103.3 FM or 1250 or 1450 or 1230 AM, we're also on the radio, and there's another FM station, and I'm always forgetting them. But we're on the radio. This will also be posted to YouTube later on, so you can see it later on if you want to. But it's always more exciting to be here in person, isn't it?
All right, you're just about to go on here.
Okay.
All right, the rejoin just started, so. Okay, go ahead.
When I left you, we were talking about how to rescind a contract, how to get out of a contract that the other party has breached, that you don't want to be a part of anymore. It's not that you want them to come and do whatever it was they were supposed to do, but you just want to walk away from it. So that would be rescinding the contract. You might also be suing for damages. So rescission is a remedy that the judge can give you. And so it's because they didn't live up to their end of the deal, and you don't even want them to try anymore. You just want the contract to end. You want any damages. So you can get rescission of the contract. And there are other situations under which a contract can be thrown out by a court, and that is if there was some sort of misrepresentation or mistake or duress or undue influence. So what do all those things mean? Well, misrepresentation means I said I'm gonna sell you this hound dog or this car, and then when you come to pick it up, it's a different hound dog or a different car. So that's misrepresentation. So that's fairly easy to get rescission of the contract. That's also a mistake of facts because the two of you didn't agree on which hound dog or car. So there are several ways that can be thrown out as a matter of law. So another is a mistake. So let's say there wasn't anybody trying to cheat anybody, but you're out somewhere and you're talking to the person. You'd say, I'd really like to buy your hound dog or your car. And you're thinking of one hound dog or car, and the other party's thinking of another hound dog or car. And again, you get there, and it's not that they misrepresented what they were selling, but the two of you are not talking about the same thing. You're not talking about the same dog. You weren't talking about the same car, whatever it was that you're not talking about the same thing. That's a mistake. And so if one party tries to enforce it against the other party, the judge might just throw it out entirely and say, look, guys, you never had a contract because you never agreed what it was you were contracting for. So that's an example of a mistake. Duress is something called, like when it's almost like blackmail or extortion, only maybe not quite that far. Duress is, somebody who promises or threatens something, but it's not quite to the point where it's an illegal threat, but they're really pressuring you to do something that you wouldn't otherwise do. Then you can say, well, I was under a lot of duress. So an example of duress would be if your attorney wanted to loan you money at a high interest rate and you really needed the money. You didn't really want to pay that interest rate. You didn't really want to borrow it from the attorney, but that attorney has your life in their hands in another situation because you have a lawsuit going on. That would be duress, which is why the Bar Association does not allow us to loan our clients money, even in a good way, generally speaking. They have decided to make exceptions to that recently. A while ago, a very famous attorney had loaned his client money to get much needed medical attention before the Affordable Care Act came in. And that attorney was suspended their license for 6 months, even though it was for a very good cause, even though there wasn't any interest involved, because attorneys simply were not allowed to loan their clients money. Now, there was a lot of outrage about that from the bar, not because we thought that he did something that was within the rules, but really the impact on it was that he couldn't do the right thing by his client because it was the wrong thing by the bar association. So they've changed the rules a little bit there to allow you to advance medical fees, and take it out of the payback out of whatever comes later. But you can't have them sign something say they'll pay you no matter what. So you're only going to get it if you win. So those are different things too. So, but that's an example of duress. Somebody who's in a position where they can hurt you, and they're pressuring you to do something with them that you really don't want to do, whether it's borrowing money or any other kind of relationship, business or otherwise. That's duress, and you cannot be held to a contract under duress. And if you go to court, you'll be, generally speaking, able to get out of it, especially if the contract is in some way unfair. Another way that court will throw a contract out is if there's undue influence. So what is undue influence? Well, that's your boyfriend or your girlfriend, or if you're elderly and you have a caretaker, or your clergy person or someone else is urging you to get into this contract, and you think that you're not going to be taken care of if you're elderly, or you think that God isn't going to love you if you don't do what the pastor wants you to do. Those are examples of undue influence. So in other words, the person has so much influence over your life that you're almost helpless to say no to the contract proposal that they make. So that's undue influence. So if you sort of wake up from your rose-colored glasses, what will happen is that if you go to court and you can prove there's undue influence, then the court will throw away the contract. You can't count on any of these things, though. Sometimes people think that they have a good case for one of these things, and then the judge just says, nope, you're a grown up and this is the contract you made and you have to live with it. So just because these are ways that can throw out a contract in court doesn't mean it will, just because you have something that sort of kind of sounds like this. Okay, so again, better to have an attorney and have it in writing. Contract law is really broad. It touches a lot of different ways. For example, even a divorce settlement agreement is considered a contract. And when we do divorces, we say that the settlement agreement is incorporated into the divorce order, but it's not merged. And what does that mean? That means it still survives as a contract. So even if for some reason you can't enforce that under divorce law, you can go to contract law and enforce it under contract law. So that's pretty important. Now, what happens if you discover a mistake in a contract? Well, that means you have to go back to the other person and say, oh, look, here was this mistake. It says, I'm going to pay you $5,000 a month instead of $500 a month, and we both know it was $500 a month. And the other person says, nope, I want my $5,000 a month. Well, you've got to go to court right away. You can't just pay them $500 a month and assume because they take the $500 a month that somehow changes the contract. It doesn't. A person not insisting on all of their rights under a contract doesn't waive those rights. And usually that's another important contract clause there. That is the law, but normally, if it goes on for too long and there's nothing in the contract about it, you have an argument. But what I'm saying is, if you put it in there, a person waiving or not enforcing part of the contract, not enforcing part of the contract doesn't act as a waiver. In other words, just because you don't enforce that $5,000 a month doesn't mean you don't think you're entitled to $5,000 a month, and it doesn't mean you can't go back later and ask for the other $4,500 a month. So if you notice a mistake in a contract, what you need to do is go back to the person, explain why you think it's a mistake, and if they agree with you, you either write up a whole new contract, which is the best way to go, or if you can't, you cross out the bad part, and then both of you initial next to the part that you've changed. So you cross out the $5,000 a month, you write in $500 a month, and you write it in numbers, and then you also write numerical numbers, and then also write it out $500 a month in words. So you both initial it, and then you re-sign at the end of the contract with a date, and that should do it. That should fix the mistake in the contract. Just make sure that you both have copies of the contract. That's another thing. Make sure you have copies of the signed contract in your possession, because it can only be enforced against someone who signed it. And so if the person who violated the contract is the only person who has the contract or a copy of the contract, you're going to have a hard time enforcing it because you need a copy of that contract. So it's very important that you do that. So how about if only one person's made a mistake? So if the contract contains a mistake, again, and only one person was mistaken, and so if both are mistaken, obviously the contract goes out the window. But what if only one person is mistaken? Well, again, We'll find out after the break.
Hello, this is Susan. Sorry about that. I was going to give you a little more time on that one because you just started. I tried to get to it before you started a new topic. But
It's all right. Don't worry about it. I think it went okay.
this is the one that's a little longer. So you're going to have about, eight, let's see, sort of 10. So you're going to have about somewhere between 7.5 and 8 minutes.
Okay, thanks.
I checked Facebook. You probably know, but it's going smooth over Facebook. So.
Okay, good. Thank you. Yeah, it hasn't blanked out on me. Thank goodness. So.
I try to check anymore ever since you had that problem that one time. So.
Thank you. I appreciate it.
I don't dare watch it because I don't know if you can hear it in the background.
Right, exactly.
That'd be very distracting.
Yeah, probably would be.
So you get feedback of yourself talking, but as long as I see it's on there, I figure it's okay.
Yeah.
All right, about a minute and a half.
Okay.
All right, your rejoin just started.
Okay.
Okay, go ahead.
This is Susan Betch-Chachoma with Law Talk, and we're back talking about mistakes people make in contracts. So let's say just one person made a mistake in the contract. Let's say, for example, you agreed to mow all of a person's property on Goff Road in Corning, and you believed that all of their property consisted of 2 acres. But you find out when you get there that all of their property is actually 20 acres. So the person who made the contract with you knew full well that their acreage was 20 acres. But you're the one who made the mistake that it was 2 acres, thinking it was only 2 acres. Well, again, this is an example of why you should have every detail in a contract as far as what it is that you're doing. You would have wanted to say the acreage that you were mowing in this, but let's say you didn't, and there was a mistake. Again, you have to remedy this as soon as possible. So you get there, and before you take any money, and if you've taken money, you give it back. Before you do anything with the contract, you say, "Oh, I'm sorry. I really thought this was 2 acres, and it's 20." And so that is not what I thought I was bargaining for. I made a mistake. And you don't take their money, you don't cash the check. And if you have cashed the check, if they paid you in advance, which they may have done, then you give the money back to them. And if they don't want to take the money back and they're trying to get you to mow the 20 acres for the same cost it would have been for 2, well, then you have a courtroom situation. In that case, you may be able to go to small claims court because it's probably not more than the small claims court level that the contract was for. But that's an example of how one person can make a mistake innocently and the other person can not be making a mistake, and there's no fraud or anything involved. But it's called a unilateral mistake. One person on one side made a mistake. So that's something that you need to take care of right away. You can't just go and mow the 2 acres and take all the money for the 20 that they expect you to mow and say, "Oh no, that's not what it was." You have to either agree with the person to reform the contract, that is to make a new contract, really to make different terms, or you have to go to court and figure out what's going to happen, and the judge will let you know. Now, after the judge lets you know, you can always appeal it, but that's often not done. Appeals don't have a high rate of success. You have to show that the judge below made an error of law. So get your contract right the first time, and then you won't have these problems. So you may also find out that you were defrauded, and fraud is a crime. So one of the things that you might want to do if you think that someone has violated the contract to such an extent that it's a fraud, contact the police and ask them. If they don't know or they don't want to take action, you can contact the district attorney's office and ask them. The district attorney's office is part of their job is to make sure that people aren't defrauded. So what would be an example of fraud? So sometimes in building contracts, we have cases that we believe are fraud. A person says they're going to build one thing and they build something else instead, and it's much lower quality and it's not what the contract calls for. But again, in order to prove fraud, you're going to have a written contract that shows what it was the person who was supposed to do. So the biggest mistake people make in contracts altogether, whether they're written, well, when they're written, is not reading it before you sign it. So you can have made an agreement and someone brings it to you and says, okay, here's our contract in writing. And then you don't read it. And then you find out, oh, later on, 5 years later in a courtroom, that you signed to agree to something that you didn't really mean to agree to. And you'll be held to that most of the time. There are exceptions, but they're few and far between, and you can't count on that. Read the contract before you sign it. And sometimes people think, like on the internet, you either agree to their terms or you don't get to use their website. So a lot of times people don't bother to read that because they want to use the website. Well, I understand that, but in the real world with real contracts, you certainly want to read it so that you find out whether or not you may be liable for the other person's attorney's fees, if there is something like an outrageous interest rate that kicks in if you're a few days late. There are laws around that too, but don't count on that as applying to you because most of the laws that are consumer protection laws only apply, first of all, to consumers. So if it's business to business, none of the consumer protection laws apply to you. None of them. I've known some people that have found that out the hard way. You're not a consumer. When you're a business person, you're supposed to be able to figure these things out for yourself and write a decent contract. And if you can't, then the consumer protection laws against high interest rates and whatever, those aren't for you. Okay. So let's talk about some big mistakes people made in contracts. The McDonald's brothers from the McDonald's Corporation actually sold the business or parts of the business to Ray Kroc twice. The first time they sold it for 1.9% of sales. So that was great. And then Ray Kroc did really well with the franchise. And so they renegotiated later. And they were supposed to get 2.7 million plus 0.5% of the sales. So 0.05 rather. So it's basically 5% of the sales. All right. So they got their 2.7 million, but since the contract was by handshake, literally by handshake back in the day, they never got their additional royalties. So they and or their families would still be getting royalties from McDonald's to this day. But since it wasn't, that part of it wasn't in writing, that part of it was only by handshake, they never got their royalties. So that was a huge loss to them and their families. A more recent one in 1998, Volkswagen thought it made a great deal buying Rolls Royce. So it bought the assets, and the contract listed what assets it was buying of Rolls Royce. And they thought, their attorneys thought, and they thought that the asset list was the entire company and that they were just writing out the list for whatever reason to be thorough and specific, like lawyers like me advise, right? So they paid 430 million for that, and as it turns out, they forgot to buy the name Rolls Royce. The name Rolls Royce was not in the list of assets that they were buying. So the people who owned Rolls Royce then sold it for another $40 million to someone else. So they bought all of the factories, all of the land, all of the machinery, the patents, all of that stuff they bought from Rolls Royce. Volkswagen did, but they didn't buy the name Rolls Royce, which was probably the most valuable asset of the company. And there was a legal dispute about it because they thought they were buying the whole kit and caboodle, but they were not. The name Rolls Royce, the brand, was not listed in the contract, and they did not buy the brand, and it was okay for the people who owned it to sell it to someone else. That was a huge mistake. Another mistake people make in international deals is that not stating the currency in which this deal is. So you may be making a deal with someone in another country and you want 500 a month. And so the current exchange rate is 500. Let's say it's 500 a month in US dollars and $50 a month in something else. You could be out of luck, and we're out of time. So that was Law Talk. Have a good week.
All right, thanks. Have a good week. We'll talk to you next week.
Okay, thanks, Frank. Bye bye. Boy, that last segment went by quickly. So, failing to state the currency, and another one I was going to talk about on the air is not saying whether or not, so you're getting an extra bonus here on Facebook, not saying whether or not a contract can be reassigned. Sometimes people will want to take their contract rights and assign them to someone else. And so all of a sudden you're dealing with someone who's not the person you were contracting with in the first place. That can happen. That's a thing. Contract rights are an asset and they're assignable. So you need to say in the contract, if you want this person to do the work on your place, so, for example, you contract for a plumber and it said the plumber sends one of his employees and the employee is not really a plumber. You may want to specify, no, I want, Joe Smith, the plumber, to come and do the work, not one of his hired employees. So that's just another thing. Assignments, tenants in apartments, can that tenant sublet it to someone else? Well, since we usually like to screen our tenants when we're landlords, we want to have a clause in there that says they can't sublet it to someone else. So you basically want to say whether or not the contract rights are assignable. Now, sometimes they can be, and it doesn't matter. If someone's supposed to deliver, 50 tons of grain a year to you for a certain amount of money, you may not care where the grain comes from as long as it's what's described in the contract. Likewise, if you have a garbage collection and, you pay for that and you have an annual contract, and then all of a sudden it's a different truck with a different name on the side of it picking up your garbage, you may not care about that as long as the garbage goes away. So you don't always need something in the contract that says it can't be assigned to someone else. But when it's important that the person that you're dealing with, it's important to you that the person that you're dealing with is the person who does it, then that's another mistake people make. So that's what we call the Facebook bonus, because you're not listening to it on the air. There's no time limit, so I get to finish telling you the important things I need to tell you. So you have a great week. God bless you. Love you guys, and stay safe and take care of yourselves, all right?